If everybody can please come to order. Welcome to Senate Judiciary Committee. We are starting at an odd time for us, and we have a hard stop for another committee, I believe at 4:30. We'll see how long we can go. We have a lot on the agenda, and so we want to get right at it. I'm going to ask Floor Leader Hatchett, will you please catch your breath and open us up in a word of prayer? What's your mic number? 13.
Let us pray. Dear Heavenly Father, thank you for letting us gather here today. Please be with us as we make decisions for the people of the state of Georgia. In Jesus' name I pray. Amen.
There you go. I want to take a second to recognize some of the aides that work in our Office of Policy and Legislative Analysis that are with us today, including Rory Chadwick, who's about to take, if y'all stand up when I say your name. Stand up. He's going to take in the bar later this month. Is that right? I believe so. Wish you the best with that, from Arizona State University Law. Also, Courtney White. Where's Courtney? Stand up. She is a 1L at Georgia State. And also Vikram Siegel, who is a junior at Georgia State. Good to have y'all with us. Thank you for everything y'all do for us here at the state capitol as well. All right, let's get right on the agenda. We'll start with Senate Bill 426. Chairman Tillery, welcome back to the Judiciary Committee. I don't have time for jokes, so I'll let you take the floor. And you're going to present LC 491658. Is that what you have? Yes. All right. The floor is yours.
Thank you. I like to say it feels like home. Mr. Chairman, Senate Bill 426 is a bill that I know many of you have worked on for a long period of time. I wish I could tell you it's a bill that when I bring it up here, everybody's going to sing Kumbaya and tell you that it's great. They're not. It was a hard-fought, carefully crafted compromise by parties on all sides, being insurers, being defense attorneys, plaintiffs' lawyers, working with the Department of Insurance, thank you, Commissioner King, and others, to reach a point where Georgia could move from where it is currently in the minority of states that allow a direct action to proceed against an insurance company to a position where we could be in with the majority of states that do not allow that direct action. The argument you may have heard from insurers and others is that this puts Georgia, the direct action statute now as it's laid out, puts Georgia at a disadvantage for insurance companies, has possibly caused insurers to either increase their rates or consider leaving the state. And then the argument from the other side was, well, hey, if you don't, if the insurance company's insolvent or we can't get service over the insurer or usually it would be in a motor trucking incident, then the person has no recovery right whatsoever because service can never be perfected, which is what's necessary, as many of you attorneys know and non-attorneys know, to start a case. Working with that premise, the Lieutenant Governor was kind enough to task me, or appoint me rather, to handle this bill to bring about a compromise that he worked and carefully crafted. What it basically says is, in Georgia, if this bill were to pass as it's written right now, you could not bring a direct action against a insurance company in this motor vehicle setting if the motor carrier if you could get service on the motor carrier and you can get service on the driver that is the most likely the original tortfeasor. That's it in its simplest form. I know this has been before before our body in various forms for at least the 8 years that I've been in this body. I want to tell everyone that I appreciate their help from the defense side, from the plaintiff side, from the Department of Insurance side, and the Lieutenant Governor's office to get it to a point where I think we can get it across the finish line this year. And I know that meant that everybody had to give a little bit. So when you get to that point where everybody's a little bit upset, maybe you finally found a bill that can pass both chambers and get signed by the governor. So thank you, Mr. Chairman. If there are no questions, I'll yield my seat.
I handed you a proposed amendment that may be offered. There may be other amendments from the committee. Do you have any comments? You've already mentioned how this was a carefully crafted compromise. I think what you basically were saying is no one's happy about the bill, but no one's too upset. It's usually probably a good sign. Do you have any comments on any proposed amendments?
First of all, there's no name at the top, so I don't know who proposed it, so I'm speaking to each of you equally. Counselor, now I can't use that as an excuse any longer.
Trying to be nice.
I do think it was carefully crafted. I would be worried that an amendment potentially would cause that to unravel. This, and I've had it for, you handed it to me when I walked up, thank you. The concern I have is if you take line 33, so this amendment in line 3, start striking at line 33. So right now it says the language of the current bill, LC 49-1658 on line 33. Starting on line 32 says, you're going to amend and revise paragraph 4 of subsection D as follows, and you include this language. This instead replaces line 33, so you're no longer talking about section 4, you're adding a letter A. I don't have the whole code section here to look at, but it looks like if you're not going to talk about section 4, you may be striking section 4, which section 4 is the part that allows you to bring that direct action suit in the first place, which again, under this bill as the compromise is laid out, you can bring that direct action when you can't get service. So without seeing the whole code laid out before me, there's a little, and I could be wrong, but there's a little concern that I would have that first part, lines 3 through 7, would actually strike direct action in its entirety, which would then, that would unravel the compromise.
Right. You have a question from Senator Cowsert.
Yes, sir.
I was just going to explain that for you if you needed me to. This amendment that language is to your bill. This isn't going back to the original statute. So
Right.
All it did is add the definition of motor carrier. Back when we first passed the original direct action statute was 40-1-112 that allowed you to sue the motor common carrier and their insurance company. There was a definition section of that defined a motor carrier to be essentially vehicles that were transporting for hire either people or goods, etc. And then when we later passed 42-140, which you also reference in your bill, that was where the DOT had the power to register and regulate intrastate vehicles. And it also had a direct action segment to it, but it didn't use the same definition that we had used for decades. It instead referenced a federal motor vehicle registration type act that had a much broader definition of a motor carrier. It essentially includes any commercial vehicle. So somebody using a pickup truck on their farm to take fruits or vegetables down to the market is now a common carrier or arguably so under 42-140. And this is to make sure we're just talking about trucking companies or busing companies. And so that's why it references that. And I just learned this through personal experience. I had a case where, the ambiguity was ruled against the insurance carriers, and I want to make sure that we just stay true to the original intent of the law. It doesn't change anything else in yours, other than to make clear a common carrier is a vehicle hauling goods or people for hire, not just any commercial vehicle.
So my concern would be if we pull that out of 33, the other impacts of what it has on line 33. I understand your point. I can't necessarily say I'd be against it. I'd have to look at it in the whole context. And then the second part on line 36, when you strike only when, does that cause an additional problem for motor carriers?
It doesn't strike only when. That's underlined. That's still in your bill.
It says by replacing line 36 with the following.
Yeah.
So on line 36, my current bill says insurance carrier only when, which is the only times you would be able to sue under direct action. But so it does strike the words only when. It replaces them to the extent
it
provided.
also replaces them with and only when, but it just inserts to the extent provided for in subsection C of 41-112, which was the original direct action statute that allowed it to be against motor common carriers.
Right.
So I put your and only when back in.
So Mr. Chairman, I may be able to accept this, but I wouldn't be able to accept it right now. And so it would cause it to delay a day, which is fine with me if the committee wants to wait and pick it up.
We already
Thursday.
delayed this from last week, and so I'd rather us get this bill today. This is probably going to be our only hearing this week because of your budget hearings conflicting with us doing other hearings as well. And so the committee will do what they want. I don't stop people from bringing amendments. I can openly oppose them, as I will here, but the committee process has to work. But for me, I'd like to see us get this compromise done. We have everybody at the table. I got a sheet of people speaking for it, nobody speaking against this as it is. And so it sounds like we could always have other moves down the road people can make in the process, or file separate bills to address other issues too. That's just my opinion as chair.
Well, in that case, and no disrespect to Senator Cowser, who has been a mentor for me for many years here, I would ask that it move through as it is because of the 5 years of putting this together. But if it can't, I understand it's the will of the committee, but I think we have a lot better chance of getting it across the finish line as it is. But if we do need to take a day, I'm more than happy to figure that out.
I do not want to delay this bill from getting out of committee. I'm happy to talk to you afterwards if you're not comfortable at this point. We can do this on the floor or later stage.
Okay. Thank you, Mr. Chairman.
All right. Any other questions for the author? Seeing none, there are 4 people who signed up to speak for the bill. We'll start with Ben Harbin with Georgians for Lawsuit Reform. I almost said good morning, good afternoon. At least it's not good evening yet.
That's right, it's not evening. Well, good afternoon, committee members. My name is Ben Harbin. I'm here today on behalf of Georgians for Lawsuit Reform. I'm a partner with Walden Edelman. We are a defense law firm here in Metro Atlanta. We represent individual insureds, companies, trucking companies, and motor carriers. I'm here today to tell you, first off, that we very much appreciate your taking time to hear this bill, to look up the cause of tort reform and specifically the direct action. This is something that motor carriers have been concerned about in Georgia for as long as I've been practicing law, for the last 10 years. So we appreciate your willingness to look at this bill. We appreciate Senator Tillery for championing this bill and bringing it for you, the committee, to consider. In no uncertain terms, this is a bill that would improve the state of play for motor carriers facing lawsuits in the state of Georgia. Currently, in every single lawsuit that involves a tractor-trailer company, a direct action is allowed. This bill will severely curtail the ability of insurance companies to be brought in and sued in personal injury cases, with caveats that personal injury attorneys can live with, that will allow them to perfect service in situations where the tortfeasor, trucking company, or employee disappear. I think that's a win for all sides. I think that this is a bill that improves the state of play, and I appreciate your consideration.
Thank you, Mr. Harbin. I appreciate your work on this issue, your group's work for many years on this issue. Any questions for Mr. Harbin? All right, thank you. Next, we have Commissioner John King. And Commissioner King, before you start, I'll say the same thing. You've been instrumental in bringing this issue to our body, and so I appreciate your work, especially over the past year on this.
Thank you so much, Mr. Chairman. I really appreciate the opportunity to come and speak to you all. This has been an issue that hit me very early on in my career as your insurance commissioner. And please understand that I'm trying to make sure that as the regulator of this industry, is the healthiness of this market is incredibly important. This is not something that insurance companies have come and asked me to advocate for. There's actually small business owners, specifically Bainbridge. A young veteran wanted to start a small trucking company. He couldn't afford $15,000 to $17,000 for insurance for his truck. And so he was absolutely excluded from being able to enter this industry because he couldn't get insurance. And so I really appreciate the opportunity to come and talk to you. I know that Chairman Tillery has worked really hard in trying to find a middle ground. I've spoken to many of you all about this. And is this perfect? No, it's not. But it's an incredibly important step that we need to take and to being able to stabilize the market for insurance in our state. Again, we're one of the only 4 states in the nation that has this provision. And that makes it unfair for Georgia business they want to start a transportation company to be able to participate in the market. by no means, especially as a career law enforcement officer, do I want to deny the ability for any person to get their fair day in court. That to me is sacrosanct just as much as I know it is sacrosanct to y'all in this committee. But I just want to make sure that people understand that we're trying to level the playing field so everybody gets a fair shot at being able to operate a small company in Georgia. You know, we talked about preserving the rights of sanctuary jury trials. Nothing will change there. I think the compromise that Chairman Tillery has worked very hard on and to include us, and I greatly appreciate his leadership in getting us to be able to get to this point. And I would urge you to support passage of this bill. Thank you very much, and I'll stand by for any questions y'all may have.
All right, thank you, Commissioner. Any questions from the committee? All right, thank you very much. Next, we have Nancy Palmer with the Georgia Chamber of Commerce. Hey, good afternoon.
Good afternoon. Thank you for having me, Mr. Chairman. Noting that you have a long agenda and many committees to get to, I just want to say that the Georgia Chamber of Commerce fully supports Senate Bill 426, and we appreciate this committee's work on it. Members of the transportation sector that we work with, as well as general business who uses the transportation sector, believe that this will be an improvement to the current situation, and we would ask for your favorable consideration.
All right, any questions for Ms. Palmer? Thank you. All right, that's everyone that want to be heard on the bill. What's the pleasure of the committee?
Do pass, Mr. Chairman.
Motion do pass from Senator Setzler. Do you have a second?
LC 491658.
Motion do pass LC 491658. Do we have a second? Second from Senator Watson. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Good job, Chairman Tillery. Come back and see us again sometime. All right, because of people we may lose on the committee for another committee scheduled after this, we're going to jump around a little bit. I'm going to let Senator Kennedy go ahead and do Senate Bill 232 if you're ready. So we're going to move down to Senate Bill 232. And you can do it from your seat. What's your mic number? 11. If you'll tell us, give us the LC number you're working off of. That.
Okay, Mr. Chairman, yes, LC number 442650S.
All right.
Is that right?
That's it.
Okay, very good. Thank you, Mr. Chairman, members of the committee. I'm going to present and tell you about the highlights of this, and I'm going to ask two judges that we have after I complete, if they'll come forward with your permission, Mr. Chairman. But this bill was filed last year, and the work has continued during the interim while we have been in the off season. But in essence, this bill simplifies the fee structure that probate courts levy for their services. The fee amounts are provided by statute and listed by the service that's being rendered to the public. For instance, a writ of a FIFE, which is contained on line 73, the details for that are found in the bill. Application for a marriage license begins at line 96, and so forth and so on. This removes the ability for the probate courts to levy a per-page recording fee, which is currently the practice of most, if not all, of the probate courts around the state. And this is actually being removed at the request of the probate judges. Some of the fees, such as petitioning for authority to open a safe deposit box, are increased under the bill. But the repeal of the recording fees results in what we believe is an overall neutral cost to the average petitioner that interacts with the probate court. Many of the fees, in fact, remain the same as they are under current structure, and because of the repeal of the recording fee, again, it is believed that overall the interaction from a filing and a fee standpoint that the public has with the probate court will actually be cheaper. For example, marriage licenses with counseling are still no fee. Marriage licenses without counseling are still $40. Overall, the bill's fee structure reflects a multi-year work among the probate judges from around the state to determine what services are in most need and are most utilized by the public, and those that are relatively unique as the public interfaces with the probate court, and also reflects a more streamlined, modernized structure. I'll tell you, for those, if you have gone to the probate court, many of which the fee structure can be multiple pages, confusing even to the clerk's office, let alone the public that interface. And I appreciate the probate judges taking the initiative to come up with something that is streamlined, it is simple, it is predictable, and perhaps most importantly, explainable to the public when they come in and interface with the probate court. I'm happy to answer any questions from the committee, but we have Judge Markham from Coweta County here with us. Judge, thank you, and in attendance, who has worked on this bill, as well as Judge Wood from Cherokee County. Mr. Chairman, with your permission, if they may assume the witness positions. And let me, and also want to acknowledge Kevin Holder. Kevin, thank you for being here, counsel of the probate court judges. With your permission, Mr. Chairman, I would ask the judges to correct any misstatements I may have made, or add a little context for what this bill really does, and any details, and answer questions of the committee. Thank you, judges, for being here.
Thank you, Senator Kennedy. Yes, I'm Carrie Markham from Coweta County. This is Keith Wood from Cherokee County, and as Senator Kennedy said it exactly right, the aim of this legislation is to simplify our fees. The aim is revenue neutral. Our fees as currently written are complicated, they're confusing, they're hard to consistently apply across the state. And importantly, they're making e-filing in our courts almost impossible, and that's something that all probate courts are going to try to work to in the future, and it's just not workable with the current fee structure. So we've attempted to come up with something to stay revenue neutral, to not raise any fees, but to eliminate a lot of the things making it extra complicated, like you said, the recording fee of $2 per page. You just can't e-file and do that at the same time. So we have support of the Judicial Council, and we're happy to answer any of the questions you have.
All right, thank you both for your work and for being here today as well. Any questions from the committee? All right, nobody else has signed up to speak on the bill. What's the pleasure of the committee? Motion do pass from Senator Watson by committee substitute LC 442650S. And we have a second from Senator Calzert. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Thank you. Appreciate y'all's work. All right, we're going to keep bouncing around a little bit. I promise there's a method to the madness. Senate Bill 424, Chairman Robertson, or I guess you're not Chairman, Whip Robertson. Come on up. Mr. Whip, how are you?
Fine, Mr. Chairman.
Good.
Mr. Chairman, I know it seems like I'm in trouble. I have a Superior Court judge and a district attorney with me, but
I
it's
see
not as
that.
bad as it looks.
You might want to get a defense lawyer too.
Mr. Whip, you might want to not answer the first question.
Yeah.
That's
Calzer, will you talk to Mr. Whip?
well.
Represent you, you'll have to work out everything.
Yeah.
Would it work if I got up here and gushed and said you were such a role model to me and all this other stuff that I heard before?
Might hurt you.
Maybe you'll follow my advice.
All right, let's get on it, Mr. Whip.
Yes, Mr. Chairman, I'm reading off LC 491716. A few months back, myself and Chairman Brass from the 28th were contacted by leadership of the fifth most populous judicial circuit in the state, the Coweta Circuit. And there were some concerns about the circuit being overwhelmed with the workloads that were going on and what they had thought of. And we met there in LaGrange and had a conversation about it with the judges, was the possibility of a circuit split. And the legislation before you right now would do that by creating the West Georgia Judicial Circuit, which would be composed of Carroll County and Heard County. And then what was left would be the Coweta Judicial Circuit. And so as far as the numbers and the concerns that have been expressed to myself and Senator Brass. I have asked the District Attorney Herb Cranford, and Judge Palmer. I didn't want to
So
call him
learn
by
the judge's name if you're going to bring him into this committee room.
well, I almost called him by his first name, and that would
sure.
have been worse.
Sure.
Yes, sir.
Do you know that at least? Or?
Judge Palmer,
Okay.
yes, are here to discuss the numbers and answer any questions about the minutia involved in the split and the concerns that they have under the current judicial circuit.
All right. Do you want to be heard now, or do you want me to take questions first, Judge?
I think we'd be happy to answer any
Mr. Cranford?
questions. I think I'll just say briefly that we're in a little bit of a unique position in that we're a multi-county circuit that has, over the last 30 years, gone from a very rural area to a suburban area. And Coweta County is the only county that borders Fulton that is not a single county circuit. We're not asking for that, but we think the circuit is too large. There have been efforts to split it for about the last 20 years. We've got the most consensus about it we've had now, and that's why we've moved this bill forward. And I think, you know, there are multiple issues. I mean, but at the end of the day, we're doing this to inject more state resources into these 5 counties. The Superior Court system is a state responsibility, but the reality is it's a partnership between the state and the counties. And we have 2 counties in the circuit that are over 100,000 people. We're the only circuit in the state that has that. And dealing with these multiple large suburban county governments is very difficult when the district attorney, the public defender, the various agencies and divisions that have to go and seek funds try to do that, because one county A can't be assured and has no way to control that the money they put into the DA's office or the judge's or the public defender's office is going to stay in that county, and there's no way that they can. And we believe that shrinking it in the way that we propose will improve that greatly. And so we'd urge passage of the bill and be happy to entertain any questions.
Yeah.
And Mr. Cranford is a lot more well versed on the numbers, because his office is the one that bears the brunt of the problem.
Yeah, respectfully, you know, as hard as we all work, I think it is my office and the public defender's office that bears the greatest burden from trying to administer justice in a 5-county circuit. To give you just a few anecdotes or data points, as he said, we're the only circuit in the state that's got 2 counties with over 100,000 people. Our 3rd largest county, Troup County, has 70,000 people, and in a lot of circuits, that would be the biggest county in that circuit. We have, out of 50 judicial circuits, we have the 4th highest felony caseload. So believe it or not, we have a higher total number of cases than DeKalb County does. They may have way more serious violent felonies.
Criminal cases.
Criminal
Yeah,
cases.
right.
Criminal cases. I'm not thinking about civil.
Yeah, right,
criminal.
right.
But yeah, so more overall felonies than DeKalb. We're only behind Fulton, Cobb, and Gwinnett. And, you know, the other circuits kind of in that top 7 or 8 are all single county. And we're not asking to be single county, but I do think that just illustrates we need to be split. It doesn't make sense for us to be 5 counties. Out of 50 judicial circuits, we have the number 5 population. From my perspective, one thing that limits us from doing, once a circuit becomes as big as we are, to get efficiency and productivity, it makes sense to have, you know, like a serious crime unit, a murder unit, a unit that prosecutes crimes against children. We really can't do that because we're limited geographically. I've got to have people in each county, particularly the 3 big counties. And so I'm kind of running 5 mini DA's offices. And I think it would be a lot more efficient and productive. And we've got quite a case backlog coming out of COVID for us to be split, a smaller area to manage. I can more effectively use resources. And as Judge Palmer said, creating a new circuit according to the current state formula would add state resources to the DA's office at very least over the same geographic area. And for what it's worth, we've spoken to the legislative delegation of the circuit. This is a nonpartisan issue. I live in Coweta County. There are 2 Democrat representatives that have the northern part of Coweta that are supportive of the bill. So I don't think, there are certain controversies that have come before with circuit splits that apply in this situation. So I also would ask for passage of the bill.
All right, any questions from the committee? Question from Senator Setzer. Do you want to ask them or the author? Or? Go ahead.
I think this is a good plan. I love your case. I'm just asking, just for purposes of due diligence, fiscal note cost. Has there been a number on that? Do we have the courthouse resource? Do you have the offices for prosecutor staff? Is all that already sort of distributed in multiple places and is covered, or is there a net cost to this?
On the state side, for the additional DA's office, and I failed to bring the exact number with me, but I got it from the Prosecuting Attorney's Council. It's a little over $2 million. Okay. For the Public Defender's Office, I think it would be a little over $1 million. I'm going to get the exact numbers that I've got to Senator Robertson on that, but I think that's an accurate.
That's an honest number. I've seen those figures.
Yeah. So you guys already have the space and real estate picked out, sort of. It's just a matter of doing the project?
There's an office.
We already have offices in all 5
all of that
counties.
is already there.
Okay, so there's no physical footprint you got to expand.
Where the DA, I mean, I don't want to speak for you, but where the DA's office is concerned, in Carroll County, they have a very nice district attorney's office that they use, for the assistant district attorneys that work there. And there's a nice office where Mr. Cranford sits when he's over there.
Yeah.
And,
same.
So it's purely personnel would be the cost.
And do you feel like this is going to make it easier to get, for example, supplements and things like that for pay, that you've got a more cohesiveness instead of having to go across multiple counties to sort that out? Or?
I think Judge Palmer kind of pointed that out accurately, and I understand where the counties are coming from,
and we work very well with the counties. I mean, and I can't remember.
Yeah, but the 3 big counties are so big. There is an understandable concern about, given relative caseloads and things, well, if I give you this much money, are the other 2 counties going to give you the equivalent amount of money?
And we have to navigate that. Now, Senator, I'll answer your question that it would. My view is it would make it exponentially easier.
Yeah, it's the old question of who is us.
Right.
Us is easier to define when it's tighter. Yeah.
Right.
Any other questions from the committee? All right. Thank you all. No one else has signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Setzler. Do we have a second? Second from Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Now, if you can just get out of the Rules Committee, it'll be on the floor. So we'll see.
Somebody, Mr.
We'll find out. Do you know his name, Matt, at least? Okay, good.
Your Honor.
Yeah, there you go. All right. Thank you all.
Thank you, John.
All right. We're doing good on time, but let's try to stick with it. Senate Bill 182, Senator Halpern, if you want to come on up, going back on the agenda. We are working off of a committee substitute. And let's make sure I'm looking at the same thing you are. LC 491755S, is that what you have? There's a.
I have 1625S.
There was another. Hold on one second, okay? Make sure I'm looking at the right one.
That might be where he added the temporary restraining
That's
order.
fine.
We're gonna hand you a copy. The only difference is is dealing with the last, I think it's second to last section, if I remember correctly, on dealing with TPOs. And I can go over some of that when the time comes.
Well, that's perfect.
But I don't think it'll affect your
It won't.
presentation of what you're doing.
So I won't delay while that comes to me. Thank you, Mr. Chairman and committee. This is a bill that you heard last year and that passed unanimously. I'm hoping that we can come to the same agreement again. And the topic is basically on doxing. A year ago, when I brought forward this bill, I think doxing was not as much in people's mind as it is now, as these problems have continued to grow. Particularly, doxing is when people release your personally identifying information without your consent, and you end up feeling harassed, threatened, intimidated. We've seen a growing trend in these kinds of activities, and states have generally taken 3 different approaches to dealing with this problem. They either have laws that allow victims to sue their doxers, they have laws that make doxing criminal, or they have laws that protect certain classes of people. For example, postal workers or poll workers or elected officials. The approach that we are taking in this bill is really the first 2. We want to give a civil recourse to people who are victims of doxing and also a criminal recourse for people who are victims of doxing. And so that is really what this bill does. Over the course of the interim, and I should introduce Sam Owens, ADL, we have worked closely to clean up the bill, streamline it a little bit more. The biggest problem and the reason why we do need to do something is that our current cyber stalking and cyber bullying laws do not actually address the problem that is in front of us, and that people who have been victims of these crimes are confronted with. And so this is a fresh approach to this very problem. And as you look through it, you'll see it's a cleaner bill. What we're trying to do is make sure that intentionality is built into the bill. There were some issues last year with people worrying about First Amendment rights, so we're trying to clean that up. But we still are making this a crime, as it should be. First offense, misdemeanor of high and aggravated assault, continue these kinds of actions, it is a felony, punishable by both a fine and time in jail. And that's it. It's not very different, but we did rewrite it, make it cleaner. We continue to have the support of organizations like ADL, Frontline, Prosecuting Attorneys Council. And I won't belabor that point, but we do have a few other things in addition to the change that you've made, Mr. Chairman, with the TPOs.
Mr. Owens?
Mr. Chairman, first I want to thank Senator Halper, and I want to thank the chair. We have 2 little changes we'd like to add, which it would be our hope that we could do an amendment right before rules. This frankly came up in large part, Mr. Chairman, and GACL and PAC agreeing to some additional language as they're in the room, and we're going back and forth with text, and the important thing is they're all agreeing to the same 2 points. In our original version, there was reference on intent that did not make the latest version from Ledge Council. Under the Supreme Court, you need to have a section on intent to make it constitutional. That language is simple. We can add it, send it back quickly. The second is, and this request frankly came straight from PAC, and GACL agreed 100%, is a reference to substantial harm. Once again, making it constitutionally appropriate, shall we say. So those are 2 changes that GACL and PAC both think should be added to the bill. And you know, you're talking about a line apiece for both of those things. So the hope was that we could work with the sponsor, get those 2 lines added, talking to Ledge Council, and then we'd be thrilled with the bill moving forward. These 2 changes are really more to help us in the
So we don't
appellate
have the
courts.
language yet. Is that something you've got to work on still?
We have the language, we just don't have the time haven't had the time to add it.
Well,
to
while
it.
I act like we're in such a big hurry, we could still get this bill out Monday. We hope to be back in here again. And so I'd rather us work on the language and make sure everybody's good here versus trying to do it after today. With our process, it makes it much easier. We have time to still do that.
Chairman, I didn't know when it would next appear. Monday's fine.
Okay. But still go ahead and speak on the bill. We'll go ahead and have our hearing today regardless, and then we can deal with the changes next week.
I would just simply add two things that have come up since you all heard this bill last time. There have been incidents where jurors had not been protected, and we've got to protect jurors in the process. There also, as I'm sure you're aware, there have been some attacks on construction sites and on homes where folks were working on construction sites, where these people have come to the residence and found that they were trashed. And by trashed, I mean 6 figures worth of damage to their property. Mm-hmm. Criminal trespass isn't sufficient, and that's really where this bill comes in. And as Senator Halpern said, 90% of this bill is exactly what you unanimously approved a year ago.
You have a question from the committee, Senator Kennedy?
Thank you, Mr. Chairman. Senator, thank you for bringing this. This, in today's world, seems very needed, and Mr. Owens, thank you for being here. Appreciate your expertise. My question is, and forgive me, I just don't know, and I was trying to make my way through reading the bill. Is there an aspect in this bill that addresses whether or not the information that's being improperly posted is otherwise already in the public domain or otherwise already available? How is that dealt with?
So Senator, in the bill, it requires intent to cause harm. So if it's already in the public domain, you'd fail on that point.
Meaning that if it's in the public domain already, you can't charge someone with doxing? Is that what that means?
You can't show an intent to cause harm if it's already in the public domain.
Okay. So can you look at lines, subparagraph B on line 49 through 51? It says a person commits the offense of doxing when he or she knowingly and intentionally post or publish another's person's personally identifiable information without the consent of the person whose personally identifiable information has been posted or published. Should that say has not been posted or published to address the issue that it's not already in the public domain?
So I think this is where the question of intent comes in. So, for example, you might be able to find publicly my home address. But if you are putting my home address out into the web on social media specifically because I've done something that you think is wrong and you are now trying to get everybody to come to my house and damage my house, that's a distinction. That's the distinction. But it could be things like bank records. It is things, I mean, in reality, people have had bank records put out into the world. They've had social security numbers put out into the world. They have had personal addresses. You just heard the example, which are real life examples of construction workers working on a site whose information is put into the world for people to come to their homes. Same thing has happened with elected officials who voted certain ways on bills that people didn't like, and were literally, their addresses were posted on a website with a message, go let them know how displeased you are. So there are some pieces of information that really is out into the public domain, but it's really the intent behind how you release it and what you're trying to cause in terms of harm to that person. And then there's the stuff that's completely not public. You should never know my social security number, but you might find it. And if I'm your colleague and you get mad at me and you release that into the world, you mean me harm by that.
So what I understand then, and believe me, I'm supportive of this. I just want to make sure I understand the breadth of it and that we're being careful so we wind up with something that's enforceable. So with the examples that you gave, regardless of whether some of that information is already in the public domain or whether it's not, this statute is triggered upon the intent
amendment.
of the person that doxed someone else. Okay.
Yeah, I mean, for instance, on line 58, it specifically says would cause harm to the person. So there's several areas in there. And then at the very end of the bill, starting on page, well, it was line 88. I'm not sure what line it is in the revision. It talks about nothing here is limiting the First Amendment.
Okay. Okay, thank you.
And you'll recall last year when I presented, I talked about the different forms of doxing, and swatting was one of the forms. I think and believe we'll deal with that separately, but it all is part of the same, kind of activity that's happening online that is meant to make somebody's personal safety insecure.
Thank you.
Senator Setzler.
Thank you, Mr. Chairman. I just, I do want to Attorney Olens wanted to say we do need to flesh out the distinction. You said that they cannot be charged with doxing if it's in the public domain. And then we heard it was an intent thing. We just need to, as members of the committee, we got to sort that out. And what level of public accessibility there would need to be. I mean, I can understand someone trying to, I can see both sides of that. I just think to have that buttoned up, I think we need to speak to that. We can't pass it and then figure out what it does. We need to go in knowing that. Also, Mr. Chairman, my concern as I read through this is, in all of these, the reference as you step up the severity of this, you've got the reckless disregard, and then you step up to the intent piece. But all of these, that it's the doxing contemplates someone would suffer death, bodily injury, or stalking. I mean, stalking is a misdemeanor, and death, if it's murder for hire or murder, you're talking about a potential capital offense. I think as we structure, I think there's I don't want to use the word fatal flaw, but I do think it's a real issue to have the same level of criminal responsibility for doxing somebody with the intent that they be killed versus doxing, which is a 7 deadly sin, potentially capital offense, versus doxing somebody that might be stalked, which in first offense is a garden variety standard misdemeanor. I think that's a structural issue we need to work through on this. I just wanted to raise that.
Understood.
And just so everybody knows, the thing I worked on yesterday on this was Section 2 in dealing with the ability to get a protective order or temporary protective order. What the sub adds in is language that's in the other code section we have for protective order as far as due process, when a hearing will be held, and the whole process we already have set out in code. I got with legislative counsel on that, and we just end up restating a lot of that here in this section to make sure, because the way it was written, it wasn't clear that those same protections for the victim, the person filing it, or the accused were actually built in. And so definitely take a look at that before we come back again and give me any thoughts you have on that. Any other questions from the committee at this time? All right, Ms. Maisie Lynn Girton wants to be heard as well. I'm sorry, yeah, go ahead, Maisie Lynn, come on up. We have one other person after that signed to speak.
Excuse me, Mr. Chairman.
Yes.
I'm not sure if you have on your lease Melanie's Ford, but I know that she also is here. And
I did not. Okay. Good afternoon.
Good afternoon. I think this is my first time this year.
It is. Where have you been?
I don't know. Busy. You guys have been doing civil stuff. You can have it. You guys can have that. Maisie Lynn Girton. I represent the Georgia Association of Criminal Defense Lawyers. I'm joined today by my colleague Sarah Becker, who is a local practitioner here in the Metro Atlanta area and chairman of our legislative committee. Maybe we could start with the back first. She does TPO work. I never have, and it could be addressed in your sub. We don't have that. We'd love to walk away with one.
We'll get you one.
But if you wanted to just quickly do that part.
Sure. I think that some of our concerns with Section 2 probably, I'm not going to take a bunch of your time because I think potentially they will be addressed here, but it revolves around the idea that I think the language hinged on filing of a petition as opposed to service of the respondent or notice
Sure.
of the respondent,
Is that what-
issues of that nature.
We tried to address that in the sub. So,
Great.
yeah.
So I won't even bore y'all with the continuation of that. I do have some concerns as somebody who has represented people on both sides of TPO work. And I think probably some of the magistrate judges or probate judges have left here, but that they might share as well, is that we see a lot of times TPOs used to address disputes that don't necessarily need the power of a TPO behind them. And we see I have seen from an advocacy on behalf of victims' side, where the enforcement of TPOs, even in domestic violence situations, is onerous for law enforcement. So I would just ask that we maybe take a look at whether or not there is a need to address this issue through TPO. I have some concerns about whether or not it may open the door to kind of Facebook feuds coming before a judge with TPO as a remedy that is not appropriate. Again, it may be somewhat dealt with some of the issues.
Is the newest, is it 1755S? Yes. Okay, so that is what we have. I'm sorry, I thought we didn't have your newest one. The procedural concern we had about this is in lines 123 to 130, and the idea that by linking it to the filing of the petition, there's not notice to the respondent. So there's just a bit of a notice.
And the intent was to make it match the other TPO,
Okay.
the family violence
Maybe that's-
statute. So
okay.
if it doesn't,
We'll take a look.
Yeah, but let's take a look at that and see
Yeah.
if we obviously want to make sure the person gets notice.
Yeah, that's what it sounded like you were hoping to do. With respect to the Section 1 of the bill, as you've heard, we've been in conversation with Mr. Owens and some of his team regarding some of our concerns, and have found some places where we can easily compromise on some adjustments that PAC is in favor of as well. Depending on where we go with the rest of the bill, we've raised with them also some concerns. The language of this bill is just really different than Title 16 generally. For instance, if you look at line 12, we don't typically define an actor. We just talk about the person or the individual. And part of what ends up happening with some of these definitions, like number 2 on line 13, a close relation. We have some definitions in the code that I think already capture these types of relationships in a way that we are, to your point, if we can use what we've got as a template, then all of the actors in the system know what we're dealing with. Because when you take this close relation definition and look down on page, it's on page 2 at line 16 and 17, one of the relationships that's described is a significant personal or professional relationship. And in fairness, I mean, I don't know. Do I have a significant professional relationship with each one of you? Maybe I think I do, but maybe you don't. And so do we know who defines that? So we will, as part of the conversations we'll continue to have between now and Monday, that's the kind of thing that we come to this legislation concerned about, because like I said, we've got some other definitions in the code that I think could grab some of this. I do realize that there is this unique aspect to doxing where you end up with these non-family violence relationships, right? Where you're having this kind of behavior happen. We would just like to make sure that it's defined well and narrow enough that you're not, that you know who you could be potentially impacting, like in your relationship, in your network of relationships. And throughout, there are a few other places where we find some of the language vague. For instance, on line 21, the idea that mental anguish shall be protracted. We don't quite know what protracted means. And that's kind of, it seems to me, a burden on the person being harmed to show somehow whether or not that harm is trivial. We do see some remaining First Amendment problems regarding, for instance, as we were talking about, you all were talking about earlier, a person's name. There's a right for redress, and some of these pieces of information could potentially still be a First Amendment problem. Another conversation that we've been having with the other stakeholders is around this idea of stalking, and I heard you mention this, Chairman Setzler. ideas that this is a different definition than what we are used to in our code, and so it's being handled differently, and it's actually at odds with the criminal definition of stalking, also a concern to us. We have already talked about and will work through the intent issues that we see with the bill. Also, again, it's mostly just the vagueness of things like what is harm, and if it's the kind of thing that you know when you see it and we'll work it out in court, great. But if we want to be clear on what the harm needs to be to rise to the level of a criminal infraction in our code, then we need a little more definition here. And then down in line 63 through 68, there seems to us to be a little bit of a conflation of intent and reckless disregard. It talks about needing to have the intent that the information will be used to harm the person, and with reckless disregard that could likely cause that harm. I'm not 100% certain this could get worked out with the language that we're going to work through on between now and then. It's just a very different way of framing a criminal offense in our code. We're used to things like classes, right, or degrees of a crime. We have first degree, second degree, and this is just laid out in a way that is, frankly, just more confusing and harder to put together. As we were sharing with our colleagues as we were discussing this bill, if this were passed today, we feel pretty confident that as defense lawyers, and I would defer to everyone's mentor, Senator Calzert, if we walked into court and said, we could file a demurrer and we are pretty sure we'd win. And that's really not, I think, the kind of laws you're hoping to pass, especially out of this committee.
You have a question from the committee?
Yes.
Mr. Leader Hatchett?
And this actually happened in my mentor's hometown, Athens.
I thought you were pointing to me.
No, let me ask you this. So last season, season 4 last, Stetson Bennett's number gets posted online, and he scores a touchdown, and he goes like this, like, call me. Obviously, that was a joke, but technically, that's doxing, and I'm assuming that it's a misdemeanor if he decided to change his phone number.
Well, under this bill?
Yes. If they release his phone number and say, call Stetson Bennett, keep him up at night.
Oh, call him and keep him up at night.
Before a big football game.
Is that mental anguish or emotional distress?
Is it protracted or is that trivial? That would be, I guess, something that would have to be discerned under this. If it was protracted, then yes, that could be a misdemeanor. Or do we consider it trivial? And then it's exempted. So I think that those are some of the things we're hoping to work out through better definition and hopefully work with other partners on the other side. But it could be. It certainly could be as drafted,
yeah.
I think.
I mean, I guess did he invite that? If he's there saying, calm, what did he do?
Well, that was after they won. I think he may have scored a touchdown and was kind of taunting the fans that. Yeah. Yeah, so essentially, the night before a big football game, fans from the opposing team release the starting quarterback's phone number, and they start calling him in the middle of the night, and his phone blows up. They're trying to keep him up at night so he doesn't get sleep, and then he either scores a touchdown or when he wins the game, he does this to the student section. Yeah. When he scores. So I just want to make sure we're being careful, and I want to be, I guess, clear on the intent of the bill. A situation like that, is that a misdemeanor? What would have to be proven? And just kind of wanted your thoughts on that. But I think you answered.
You'd have to suffer a substantial life disruption. And does one sleepless night rise to the level of substantial life disruption? Certainly I'm going to argue it doesn't, because, I'm a mom of young children. And,
it's every night.
Well,
every night we're so at some point we've got to draw some lines about, what's...
That's a fair point, but a substantial life disruption it's specifically defined as changing your number.
Yes, such as, yeah, it is. That is one of the examples for sure. I don't know if this is what you mean to do, but what it sounds to me like is you're proving our point that we're concerned about the breadth of this language.
Yeah.
The vagueness.
Well,
of
I
it.
mean, I'm trying to understand the bill.
Yeah.
I'm not advocating for or against at this point. Just trying to understand what the unforeseen consequences could
Yeah.
potentially be.
Any other questions from the committee? All right, thank you all.
Thank you.
We also have Ms. Charlotte Jackson with the Prosecuting Attorney's Council signed up to speak. Good afternoon.
Good afternoon.
I've had an opportunity to speak with, I guess last session with Senator Halper and Attorney Olens, and we do agree that we do need a crime of doxing. We do have concerns, though, with the, we actually agree with Gactel that we do have concerns with the definition of stalking. If it's going to be a criminal charge, that they need to be consistent throughout the code.
Are there any other concerns you have? As I will agree that, and I don't do a lot of criminal law in my practice, but reading this, it does read a little differently. It's got more detail. I know this is a unique crime. That was one of the things that Gactel brought up. Is there any other concerns in the language outside of that stalking paragraph that you have from a prosecutor standpoint trying to bring one of these cases?
There's just the important part about the stalking is that the behavior is done for the purpose of harassing and intimidating. And the one thing that we want to kind of keep in mind too is it's not just us reading this, it's law enforcement officers out on the street. So victims are reporting crimes, and when they're describing it in a way that is difficult for law enforcement officers to apply the statute to, it makes it difficult for them to get help and for them to make cases.
Senator
Other than
Setzler.
that, we don't see any other changes.
Okay.
Thank you. Appreciate you being here. Do you know any other statute in which, well, let me ask this a different way. I'm asking more directly. I raised the question before of the same action that was seeking to induce the death of someone else versus the same action which is seeking to induce the stalking of someone else. And again, was it 590 stalking, misdemeanor. Can you think of any other statutes that we should instruct us where the underlying action would be inducing a misdemeanor act, or an act for which you're essentially inviting or recruiting somebody or promoting an act which would be a misdemeanor versus inviting or recruiting or promoting an act which would be a capital offense or 7 deadly, where either of the two that you're trying to sort of be a catalyst for are so broad in their severity, but that would carry the same underlying offense penalty itself?
Probably the way to look at it would be soliciting people to do something annoying that would cause harm.
Yeah.
That could be misdemeanor behavior, and looking at another subsection, engaging in behavior that would cause physical harm. I can't think of a statute off the top of my head.
And that's exactly where I was going. The criminal solicitation statute, if you criminally solicit someone for a misdemeanor act, it's a misdemeanor. You criminally solicit someone for an act that's this felony, it's sort of progressive like that. Would we not, in keeping with law, want to maintain that level of balance if you're, whether it's criminal solicitation or if doxing is another form of criminal solicitation, you'd have that kind of balance. I don't know anywhere in the code that you don't maintain that.
I don't think that would be unreasonable.
Any other questions from the committee? All right. We also, is it Melanie's Ford that's here? Want to come on up as well?
I'll be brief. Melanie Ford, I had the pleasure of being before you all last year when this passed unanimously. I'm speaking as someone a lifelong resident of the state of Georgia, and asking you all to help protect me because I am on the receiving end of being doxxed, and it is not a pleasant situation. Just shortly put, I purchased a cookbook from someone who pretty much turned out to be a crazy. Forgive the terminology, but it's what it was. And because I was no longer interested in being a customer any longer, my information was taken and put online. One of the things that one of the senators put forth before, which I'm learning in real time, the concern of doxing, and I hope everyone understands the definition as it stands now. It is the searching out of private and personal information, placing it online with malicious intent. So I think I felt maligned when we're focusing on the malicious intent. Right now, if any of you were to go out and buy a home, if you don't take extra steps, there's a good chance that that information is filed somewhere publicly. And with a good Google search, the example that I used last year was there are individuals out there that can pay $19.99, $29.99, and these databases have information of your mother's name, your children's name, because in some form, somewhere, you have opted in and put that information out there. Whether it's you giving your zip code at CVS or whatever it is, we have to be mindful about our own information. But there's information out there that could potentially hurt you. I'm focusing on because I have been on the receiving end of the malicious intent. Just because a person can pay $20 to find out my social security number or my home address, is it, and I think this is what this bill is trying to address, is it right for a person to seek that information out and put it online? It's malicious to do so. What is the reason behind that? Illinois in last year of August of 23 is the last state, the latest state in the United States to adopt a doxing law. It covers things like not being able to post social security number, home's address, children's schools and things of that nature. Currently, as I understand it, we have nothing like that that addresses that here in Georgia. Again, someone can go and find out this information and post it online and make you vulnerable. I don't know any of you anyone sitting in this room that would be comfortable with me being able to go and find out your child's school and their bus schedule and posting that online. What's the reason why? And so I think because of what I've experienced, I did approach Senator Halpern, and last year you all, I don't understand the minutia. This is what you all do all day. I can just speak from someone who has been on the receiving end of that information, and it was dangerous. This person not only published my address, but the address of my elderly parents, just because they were annoyed with me. And I received a death threat as a result of that. They said they were going to hunt me down and F me up, and they were going to hurt my parents. There was nothing I could do about that. Nothing. You could take civil recourse, but there is no law that prevents, at this time, someone making that. That's a long road to try and go through the courts. And I'm hoping that we get to a point where there are just certain things that just should not be. And I know there's a lot that has to be figured out, but I see no reason for anyone to know where you lay your head at night or where your children lay their heads at night without your permission. I'll take any questions if anyone has any.
Thank you, Ms. Ford. Anybody have any questions from the committee? Senator Setzler.
I do for the chair, but I'll ask it later. Thank you for coming today.
Absolutely.
Yeah, thank you for sharing your story with us. No one else signed up to speak on the bill. We're going to continue to move forward and work on some more language. Senator Setzler, do you have something you want to add before we move on to the next bill?
Yes, Chair, maybe members of the committee, what is the expectation of privacy? For years and years and years, every year I get this big fat phone book dropped off on our front porch every year, and I could look up any of my hometown, look up their address. We can go online and look up people's white pages number. I know it's not as easy to find as it used to be. What is the expectation of privacy for someone's home address? And is that something that is a valid? I mean, I know it creeps me out too, the idea that I'm a private citizen, and conceptually it's creepy, but I mean, it's not new. I mean, it's having someone's home address with a phone number has been out there for years. I'm just having a conversation here. I'm not advocating. I'm just asking the question. Does someone have what is the legal standard, I guess, Mr. Chairman? Is there case law around that?
Yeah, I don't know the answer to that last part. I'll just say I think the intent of the bill deals with the intent of the actor. And so, I mean, there's a lot of information, I guess, beyond just someone's address that might be in the public domain. It might be something that there's not a big expectation of privacy on. But if you share that with the intent to cause harm to that person, I know there's different levels that in the bill. I think that's where they're trying to get at, not so much maybe how much expectation. You want to address that? As far as expectation of privacy.
Thank you, Mr. Chairman. I think only to add that in general, remember now, doxing is not just I'm talking to my friend, my one friend on the phone and giving your address. Generally, doxing is in social media or on a website and taking people to that person's home. Driving people to a website that has your address on it and saying, go talk to them. It's dropping paper. Doxing is technically dropping papers. You dox somebody. It is specifically not just you and me. Like, it's not here anymore. It's the world and you. So that's also a distinction with doxing that makes it very different than, you're right, we used to get the phone books. There's nothing inherently wrong with somebody knowing your address unless they're trying to do you bad by that knowledge, by that information.
Yeah, and to the author, I mean, to me, the link ties to it's all about the intent and what you're trying to do with the information. I think,
correct.
If we can be clear that, this is the question of, is public information or information in the public domain something that is can that be the modality through doxing if the intent is there to get people to turn out to swarm your house? We've got to answer that question. I don't know that there's an expectation that folks don't know your address as such, which means this bill is more centered around this issue. As you said, Mr. Chairman, did the action of putting out there by itself do anything? You'd seem to have to prove an intent element that's very substantial, that it centers on that not right. This information or that information. Almost the kind of information may be immaterial. It may be the.
And I guess this is a crime where you also have to show the effect, obviously, too, because
right.
The harm. That was what Mr. Olens was mentioned.
That's right.
I don't know if I agree necessarily that it could be something in the public domain, but your point was, well, if it's already there, how are you going to be harmed from it being shared? I guess it depends on how it's done, but yeah. All right.
Thank you, Mr. Chairman.
Thank you.
We'll come back. We'll continue to work on the bill and shape new language.
Sounds great.
Thank you.
Thank you all for your work on this. All right, last bill on the agenda, Senate Bill 320. Senator Rhett. We are working off of LC 442359. And this, we had a hearing a year ago at some point. You can do it from there or down here, whatever you want to do. On this bill, but I believe we heard it really late last year and we're not ready to take action. So you bring it back to us again, and my understanding is this is the same version that we heard a year ago. Okay. Yeah. Okay. Thank you.
Yes, sir, Mr. Chairman. We did come with this last year near the end, and we said we'd bring it back, and here we are. We're back. Basically, the legislation would require any person alleged of a sex offense to test for HIV within 48 hours of the presentment or service of indictment or accusation. In any case, AIDS transmission criminal case where a person is found guilty, pleads guilty, or pleads nolo, the person must test no later than 48 hours after the verdict or plea. If they did not take the test at the time of the indictment or accusation, follow-up testing would be given as appropriate, determined by a physician, and the victim or victim's family would be notified of the results. I have Ms. April Ross here, who's the architect. And
Yes, so this came about through a requirement that we were made aware of that is tied to federal grant money through an OVW program. And so all of Georgia organizations, departments, any state, anyone tied to Georgia who gets federal funding under these programs is subject to this condition that somehow got put in here. This is relatively new, but it would until Georgia's statute is, I guess, in compliance with this condition, every award will be subject to a 5% withholding. And so what they're really asking is two primary things: that if a victim of a sexual offense requests that the defendant be HIV tested, that testing must occur within 48 hours after an indictment. And secondarily, that there can be a provision for follow-up testing if a doctor deems it medically necessary. Those are the two primary provisions that are required to be a part of our statute, or that our statute is required to say in order to avoid that 5% withholding. Let's see here.
So we're currently having that 5% withheld right now?
Correct. Yes.
Okay.
The letter that I received advised that, yes, the award we received, that we were awarded in FY '22, was flagged and has been put on a 5% withholding. I looked up, under this OVW award program, how many Georgia organizations are currently receiving funding. I looked at 2023, and there were 22 organizations under one of these grant programs, and the amount totaled $16.3 million. So over the course of, over a number of programs, the dollars start to add up, and 5% starts to look like a significant amount of money that could be going to programs for victims, and programs that assist with developing and improving our response to domestic violence, sexual assault, and stalking offenses.
it's the Office of Violence Against Women who administer this grant. And of course, we're not in sync with them in terms of 48 hours. I think currently what the state is, what,
45 days following, yeah.
So who actually does this testing? Because it's a big change to go to 48 hours from 45 days.
So this is what's interesting, and I have a little bit of limited knowledge here because I've been doing a lot of searching, but as you know, we're a non-unified court system in Georgia, and so are our jails. So this is pre-conviction, so this is not the DLC. Essentially, this is going to come down to some combination of sheriff's departments and whatever their current process is for maybe working with DPH to get testing done, which is what the statute currently requires, is that it goes through DPH. But as I understand it, it would be the prosecuting attorney that is notified by the victim that they want the testing done. The prosecuting attorney would then somehow notify or get an order of the court, and that would start the clock ticking.
And then DPH does the testing? Is that what you're saying?
That is what it appears to be. Now, I don't have any explanation. I tried reaching out to some sheriff's offices or to find out what the process is, but to be perfectly honest with you, I couldn't find anybody, prosecutor or sheriff, who has had this happen in recent years.
That was why I was looking for, is there anybody that's saying we can't comply with that time period? I've heard in the year, I don't know, you would know better than me, Senator Rett, but no one's reached out saying that this is a move that they can't comply with. Have you heard from anybody worried about how, because it just is a huge change in the code. I just want to make sure we can actually comply with it.
I have not found anything that says no, but I also haven't found anybody who's actually done it.
Right. Okay.
To be fair.
Yeah. All right, you have Senator Jones. Is that who's pushing? Senator Jones.
Mr. Chair, I did have one question. It's on line 23, and this may go
also my question about compliance, where it says about a showing of probable cause, would that showing of probable cause just come from the initial indictment or accusation, or would someone have to actually go to court and then show there's a probable cause?
Yeah, so what you're talking about is in the situation where a person declines and
Right.
does not want to submit to the testing and their results being provided. In that instance, they would essentially go to a probable cause hearing before the court to show that, A, they're likely the person that committed this crime and that the crime may have involved significant exposure. That's what our bill currently requires. And so upon that probable cause showing, the judge can then order that person to comply with the testing and the release of the results.
Okay, all right, thank you.
Senator Setzler.
Thank you. Thank you for the intent of this bill. I'm going to follow up on the whips question. But first, the shot clock thing, I think there's some value in these kinds of things. As I look at this, if you've got to go and demonstrate probable cause, is there any concern you've got about how long it takes you to get into court to be able to demonstrate that? I mean, we have 48 hours for the test, but I hear people having to wait and get on the calendar to get even things like this.
So here's what's that's striking right at the core of some of the problem with actually the law in general, and you know, sort of curious behind why they want this requirement. In reality, by the time someone's getting to the point of indictment, that assault has occurred a long time ago. We know now today, and at the time that our current law was created, probably 20, 30 years ago or more, we didn't have some of the resources we have available now for a victim to get tested and to find out if they may have been infected with a disease like HIV. And so what would happen is, yeah, sure, by the time you get to indictment or going to that probable cause hearing, yeah, a lot of time has passed, and the value of that speedy clock, you know, the 48 hours is pretty severely diminished anyway by that point. But at the end of the day, you know.
Let me ask a crazy question. I mean, I'm flying blind here. I mean, if you've got an alleged sexual offense for which there's presumably there's an arrest, is this not something that ought to be considered before the person's released? I mean, before you put, if they make, I mean, I know in Cobb County, a lot of, certainly the more serious sexual offenses, they're not releasing people, but even if you do post bond and get out, is this something we ought not do while the person's in initial custody?
Theoretically, I think the answer to that is yeah, we would. But I think part of the motivation for putting the clock at the indictment is to give some due process to the person. An arrest has a lower, I guess, requirement of or standard of proof than when you indict somebody. So I'm assuming maybe that's the reason behind their requirement for an indictment. They're essentially trying to get us to mirror a part of the U.S. Code, 34 U.S.C. Section 10461D, and they currently have that requirement at the time of indictment. I'm not asking this because it's going to somehow be prejudicial. I'm sorry, or it's not going to be probative to the facts of the case whether the crime was committed or not. It really comes down to an issue of exposure for the person's health, and I know there's a privacy interest there of someone's, what interest is there to get the person's medical status, test them for HIV. I just don't know that that's not going to have any impact on the final adjudication of the crime, guilt or innocence. It's a matter of medical exposure. Is there I mean, if you can demonstrate factually, even if the crime wasn't committed, but you can demonstrate factually that somebody against their will had someone's, again, these circumstances, mucus and blood and whatnot,
if that was forced upon them, even in a tortious act that wasn't even a serious crime, don't you have an interest in figuring that out? And do we need to push this back to the indictment, or can you do it sooner? I would just ask that.
I agree with you, and I think one discussion we had actually just this afternoon before coming in was, in the situation where the person isn't declining or refusing to submit to the test, but instead is consenting upon the request of a victim. At the point of consent, if they consent right away, you might as well go on and start the clock there and get that testing done within 48 hours. But I think that makes sense. As it stands, this is drafted based on basically the requirement that they asked us to follow. So I'd be open to it getting done sooner. I think there is an interest in that. I don't know, again, though, if at the point of arrest, if there's since it's just a lower burden in terms of what it takes to arrest somebody versus getting that indictment, that true bill, if that's maybe why you're giving that person that,
I mean, I think you got to have, I think the standard for arrest, I think it's this, would you not have a probable cause standard for to actually put someone, handcuff somebody and read them their rights? And I think the standard's the same.
Is it the same?
So I'm not trying to solve a problem in a way you don't want to solve it. I just don't understand why we would postpone this to potentially weeks down the road. If you've got the person in custody and there's a health interest or health concern, why don't you just do it while you got them? But.
Any other questions from the committee? Senator Parent.
Thank you, Mr. Chairman. Thank you, Senator Rett and April. It's good to see you. I actually would just like to see the letter that you referenced and learn a little bit more about the group itself and the grants, and figure out, what knowledge could you share about how other states are handling some of these kind of complex issues of due process and meeting the requirements that.
I tried to do some research. I actually submitted some FOIA requests to them to try to encourage a little more disclosure. And I have the letter here you can take a look at if you'd like to. But what I've learned essentially is that at least 20 states so far are already in compliance with what their, I guess, language is asking for. I understand that, let's see, yeah, just essentially, I was just told that 20 states are currently complying with that federal HIV testing requirement. And they're mirroring the federal law.
So going back on the questions about the triggering of the clock, the way the current law is written, it looks like an arrest, there's just not a time period put on it, but an arrest is when someone can make the request. And the way the bill's written, it just has this this provision that says that it has to happen within 48 hours after the indictment or accusation. But I guess the way it's written, what would prevent a judge still from ordering it sooner if they still wanted to order it prior to that? Am I reading that wrong?
Yeah, I don't think anything would prevent a judge from ordering it sooner. If there's consent, there's no refusal, and if that victim requested, at an early time prior to indictment, I don't see any reason that this would prevent the judge from doing so.
And then if they didn't consent, you would then have a probable cause hearing that would happen.
Correct.
But then it still says upon indictment. I guess there's a situation though where someone's arrested, they haven't been indicted, they
Right.
don't consent, you have a probable cause hearing prior to indictment, and they still,
You still
a
delay.
judge, I don't know what would prevent a judge from ordering it sooner,
And
unless I'm misreading it.
Yeah, I can go back. I vaguely recall going back and forth, in fact, with the federal attorney or advisor attorney about that question, because I think that's how I originally drafted it, which is
And-
after the probable cause hearing, could that start the clock at that point? somehow they brought me back to this language of upon the indictment or.
Well, Ledge Council usually tries to clean us up when we go on a rabbit trail to put us back on track. Mr. Walker, if you can.
Thank you, Mr. Chair. My nod was to indicate that I would be very happy to get involved. I didn't draft this particular
Oh, I thought you were
bill.
about to give us the answers.
And in as much as no action is taken on the bill today, I would be happy to get involved and work with Ms. Ross and Senator Rhett and address some things.
Okay.
Yeah.
I think it'd be a good idea to do like the senator from the 37th and find out when does that shot clock
Yeah.
start.
We do have one of the persons out to speak. Anything else from the committee? Senator Jones, do you have a question? No. You sure? Okay. Okay. All right. Thank you all. We're going to have Miss Maisie Lynn Girton. Maybe you can straighten it all out for us. Or are you going to make it more confusing?
Ms. Ross was talking about the conversation she was having earlier, and it was with us. Because we come to this bill just mostly curious, not totally opposed to it. I mean, I was distracted by another task at the very beginning, and I don't know if Ms. Ross explained that there is no nexus between the money that she's receiving from the federal government and this HIV testing requirement, which I find fascinating and unreasonable. So the money that they have gotten, this grant money, is being used to fund sounds like a really great pilot program to try to make sure that people who are connected to someone who has been violent toward them gets notice if that person gets turned away from buying a gun, so that they can take some safety measures of their own. So they're going to run this pilot program to try to help people who could potentially be further victimized in this gun-related scenario. But now the feds are saying, because Georgia doesn't have this prescribed HIV testing, rubric, we're going to cut your funds back. But here we are, because here's the other piece. When we read this bill, we thought, oh, this is a chance, this is an attempt to try to get people care sooner, who need it and deserve it. And we were like, there's got to be a better way than this. And even our friends who work specifically in the HIV context said, the way to help people is to get them PrEP and medication when the outcry happens, right? Tying this to even arrest can be too late in sex crimes. Sex crimes sometimes have quite a delay from outcry to arrest. And if there was an HIV exposure, even the 48 hours from arrest can be too late. So in some ways, assuming that other processes are working where someone, as a result of, for instance, having a rape kit done, does get access to medical care that is relevant for the potential of any transmissible disease happening through the criminal act that is alleged, in some ways, this timeline becomes irrelevant because it can be so far down the road. Whether you tie it to arrest, certainly if you tie it to indictment, as we already do, is terrible, because sex crimes, some of them have a 7-year statute of limitations before you have to indict them. And so if you're talking about 48 hours after 7 years, that ship has sailed for these victims. It's hard for me to come and say, if we just need some language to get this money flowing, there's very little harm. I can't quite go that far, right? And say we have no trouble, in part because when you add this medically appropriate construct down beginning at line 40, this medically appropriate follow-up tests, by whom, on what terms, is there due process embedded in this process? It does rely on the rules and regs of the Department of Health, but again, this is language that the feds are requiring for this money to flow. The other concern we have is around the money, not so much for our friends at the Sheriff's Association, but back up on line 27, one thing this bill does is requires that now the only person who can possibly be required to bear the cost is the person that's arrested. And we don't love that. It's certainly in the discretion of the court to not require that, but I'm not sure who else then would be on the hook for it. And this is potentially happening if you're at this line 27, it's happening in that situation where the person has declined to consent. The judge has heard a probable cause, made a probable cause determination that they should have to get tested, and they're paying for it. I just don't love it. But in talking with Ms. Ross, I feel like we are sort of equally confounded by what's being asked of you guys in order to access this money. I don't know, to her point, and the conversations, the fact that the Sheriff's Association's not here saying it's a problem, perhaps this never even gets used. And so if the words on the page are needed to get the money for these other good programs, I just don't love that that's the choice you guys are having to make. And those are our concerns with the bill.
All right, any questions from the committee? Thank you.
Sure.
All right, we will, at the request of the author as well, hold on taking any action as we work on the bill, get some more questions answered. And that is everything we had on the agenda. So just in time, Senator Watson, you want to close us out in prayer, or are we good? We're good. With that, we're adjourned.